So good morning, everyone, again. I can see we've got quite a few people now attending. So I propose that we start this last Cornerstone Housing Week webinar. In the usual way, this webinar will be available on the website after we finish. Our subject is data protection legislation and how it interacts with landlord and tenant relationships and litigation. So this area requires cross-disciplinary expertise, and that theme allows me to make a shameless plug for our Cornerstone titles. Here we go, popping up on the screen. So you can see here that this is a selection of some of the Cornerstone titles which may be of interest to you on housing licensing, ASB, social housing fraud and information law. So today we have our speakers, an expert panel who are going to be dealing with various aspects of how information law interacts with landlord and tenant litigation. And we have Matt Lewin starting off with top tips for landlords, John Fitzsimmons, who will deal with CCTV and noise recordings and the like, and finally Kuljit Bogal, who's going to talk about the sharp end, which is using evidence in court and how that interacts with data protection. Each of the speakers is going to aim to speak for 15 minutes, and then we will have a Q&A. That said, do feel free to use the Q&A function during the talks, and the speakers will try to respond during their talks, either via the Q&A function or live. I just remind you of the need to observe confidentiality. So particularly, obviously that always applies, but particularly when this is going to be recorded, any cases should be anonymized and details should not be referred to that would enable specific cases to be identified. It may be that if you want advice on a concrete situation, that the answer will be, please could you put that request in writing and send it to Chambers wrapped in a pink piece of ribbon. But in any event, if we don't have time to deal with a particular question today, then the panelists would be pleased to discuss it further with you outside of this arena. I'd also remind you that you have an opportunity to give feedback at the end of this webinar. And that's not only an opportunity to say how pleased or displeased you were with how the speakers performed, but also importantly to give us suggestions about what you'd like to hear from us in terms of future talks. So that's an important opportunity for us to discuss what would be helpful to you in your practices. So with those introductory words, I will pass over to the first of our speakers, Matt Lewin.
Thanks, Matt. Good morning, everyone. So I think about if we'd been running this session 2 years ago, and I'd said the headline slot of the Cornerstone Housing Week, the final webinar, or the final event of our Housing Week would be on data protection, and we persuade 130 odd people to sit in front of a laptop screen for an hour and talk about data protection. I don't think any of us would have believed it, but thanks to GDPR, this is now a much more exciting area, and it's something that I think everybody appreciates they need to know at least something about. So thank you very much for joining us. The topic for my talk this morning is top tips for landlords. And while John and Kuljit will be thinking in very kind of concrete and practical ways, I'm thinking of data protection here in a fairly broad sense. So how to make sure what you do with personal data matches up with the expectations in data protection law. And when I'm talking about data protection, I'm talking primarily about tenants' data, but it's also important to remember that a lot of what I say applies beyond tenants. It applies to staff and others as well. So if we could have a look at the overview slide, Colgett, that would be great. Okay, so the overview of the talk, I'm going to highlight 3 important areas of data protection compliance. Firstly, data protection policies. Secondly, tenants' rights. And thirdly, data sharing. But again, remember that when we come to tenants' rights, those rights can actually be exercised by anyone whose personal data you're processing. So we'll start then with data protection policies. Excellent. So data protection policies are a really important aspect of data protection compliance. And one of the main innovations that the GDPR brought about was the idea of an accountability principle. So if you've done any training or any work or spent any time thinking about data protection, you'll be familiar with the data protection principles. Data must be processed fairly, lawfully, transparently. You've got to make sure that you're holding it securely, those kinds of things. But new in data protection law, thanks to the GDPR, is this idea of accountability. And what that means is that it's not enough just to comply with data protection obligations. You need to be able to positively demonstrate you're doing that. And that means that a good set of data protection policies is one of the best ways to show that you're accountable. They turn general principles like data minimization, purpose limitation into real, meaningful actions that can actually be put into practice by your colleagues in your organization. So what areas might your policies cover? Well, I've highlighted a few aspects on this slide. Now, the first bubble is general and specific. Now, what I mean by that is that most of the social landlords we work with, and having a quick scan through our participants lists, most of the social landlords represented today, they're fairly sizable organizations. They're managing a lot of properties and they're using a lot of staff members to do so. So this means that they're processing large volumes of data all day, every day. So for organizations of that scale, it would generally be a better idea to have a general high-level data protection policy and then specific policies to cover particular business areas. So income, repairs, complaints, they will all process data in slightly different ways, hopefully with a kind of common theme, which can be covered by your general policy, but you'll also need to reflect the fact that different kinds of processing activity will be going on depending on which area of the organization is doing the processing. So a general policy is one that obviously applies across the whole organization. And what it should be doing is things like setting out some key principles or objectives, privacy principles or objectives for staff members to work towards, and general information about data subject rights, which we'll obviously come on to in a moment, how to recognize and respond to those. And as I said, the specific policies covering particular business areas. Information security is obviously a really crucial area. We need to avoid personal data breaches for financial reasons. There's significant enforcement powers given to the ICO by the GDPR, but just as much for reputational reasons as well. So it's really important that your policies are giving up-to-date security advice. So when I was working for Camden in the housing department 10 years ago, the advice was keep your password updated and change it every month, every 2 months, something like that. Things have obviously moved on a lot since then. So it's really important that your staff are adopting up-to-date information security practices, and a policy is a good way of communicating that. Thirdly, records management. Now, good records management practice feeds into a number of important areas of data protection compliance. And I'm thinking particularly here of complying with subject access requests. So if your records are properly and rationally arranged, then it becomes a lot easier to comply with subject access requests. And if they're securely stored, then we're mitigating against the risk of a personal data breach. So records management, I think, is something that needs to be addressed in a policy. Finally, and topically, working from home. Now, over the last 7 months, I imagine a lot of the people on this webinar have become more or less full-time remote workers. And that changes, that introduces new areas of risk in data protection terms. And the main data protection risk that I'm thinking about here is information security. So you might be using a personal, potentially a family device to do your work on a day-to-day basis. You'll be using a home internet connection, and all of these present potential security risks. So some of the areas that I think a good working from home policy should cover, things like devices. What devices are your colleagues using to do their work? Is it a company device? Is it a personal device but with a remote access option? Or are people just using their own devices with no remote working capability at all? Each will present different challenges which need to be properly considered when deciding what policy your organisation is going to adopt. Additionally, data storage. So a lot of data will now be being stored in the cloud, but you need to think about, is this cloud provider an appropriate one to be using, and are we actually using it appropriately? So there are rules about where servers should be located, and ideally they should be located within the EEA, a European-based server, and ideally data going into the cloud, or at least sensitive data, should be encrypted. Video conferencing is another topic. Now, this was at the beginning of lockdown extensively covered in the news because a lot of armchair cybersecurity analysts, probably with a lot of time on their hands, started to look at the inner workings of things like Zoom and started to pick all sorts of holes in their model. It seemed to me the main issue was less to do with the internal workings of the cloud video providers, and more about the inexperience and naivety of the people using it, not locking down the meeting with appropriate security settings, things like that. Now, you will be using Zoom or Teams, services like that, potentially to process personal data of tenants and others. So it's important that you're doing that in a secure way. And finally, communication. So with colleagues spread over a large distance, a lot of us are even more reliant on email than we were before, which is obviously a great shame. I've not been able to persuade any of my colleagues to ditch email and join me on Slack. But obviously, as we adjust to the era of remote working, we're hopefully introducing new ways of staying in touch. So it's important that that's done in a secure way. And also, if you're subject to FOI, that colleagues should be aware that even though some of those communication channels encourage less formal communication, it's all potentially disclosable under FOI or potentially under a subject access request. So that's it for policies. Moving on then to the question of tenants' rights. I'll just wait for my bubbles to catch up with me. Okay, so tenants' rights. This area can be a bit of a minefield, and in my experience, it's increasingly being used as a litigation tool. So it's now common for subject access requests to be made as a kind of early warning shot in litigation. That might be a claim for JR. It might be, and I'm dealing, a lot of us in Chambers are dealing a lot now with just freestanding data protection claims. So claims based often on personal data breaches, or indeed in a defence. What does the landlord hold on our client, and how can we deploy that in the litigation? Additionally, failure to comply with data subject rights can also result in complaints to the ICO and potentially enforcement action. So it's really important to get this right. And that means setting up processes in advance to respond efficiently when requests are made. So as I said earlier, focusing largely here on requests made by tenants, but bearing in mind that actually requests could be made by anyone whose personal data your organisation is processing. Now, not all data subject rights are covered here, but I've focused here on the ones that tend to come up more often in practice and the ones that can be more contentious. So starting with the right of access, this is known as a subject access request, sometimes abbreviated to a SAR, S-A-R. Its purpose is to give individuals a copy of their personal data, but importantly, it's not limited to that. So firstly, a subject access request response needs to confirm that you are indeed, or if not, that you are not processing that individual's personal data. If you are, then you provide them with a copy of that data, but you also provide them with processing information. So it's a similar set categories of information to that which you would provide in a privacy notice. It tells the individual in the response what you're doing with the data and why, what data you're processing, who it's being shared with, how long it will be retained for, things like that. Most people will be familiar with SARs, and a lot of you will have dealt with them, and some of you might even have made them. A few important things to know as a minimum. A request now under the GDPR can be made verbally as well as in writing. It can be made to any part of your organization, so not just the information rights team. It could be made through social media. So it's really important here that staff are trained to recognize a subject access request, and crucially that they know who to pass it on to. Another change brought about by GDPR, we can no longer, in the vast majority of cases, charge a fee for responding, and the time limit is 1 month, although it can be extended where the request is complex or where we're dealing with a repeat customer who has made lots of requests in the recent past. Another important but quite subtle point is that the right of access is a right of access to data rather than documents. So it's not like a FOIA request where you just request disclosure of certain documents. Under subject access requests, the right is not access to any document that happens to have your name in it. It's got to be personal data, which in very broad terms means information about you, information about that individual, and I emphasize the word about there. Second right that we're looking at on the slide is rectification. This is a right to have inaccurate personal data rectified, so corrected if it's inaccurate, or completed if it's incomplete. And data will be inaccurate if it's incorrect or misleading as to any factual issue. So that in most cases that won't cover expressions of opinion, which tend to be subjective. We're talking about things that are objectively true. Now you might be less familiar with this, but it has been around for a while, and it can be relevant for social landlords. And I'm thinking here of back to my time in Camden. I was trying to arrange an allocation to a really lovely man, but this was a sensitive let, and this man had a note on his file saying that he there had been allegations of, well, I won't say any more than bad behavior against him, so he wouldn't be an appropriate candidate for a sensitive let. Now, as a result, he was denied the allocation, and had he been clued up on his data protection rights, he might have wanted to know, firstly, what have you got on my file? What's the marker against my name that's prevented me from getting this let? And he might have wanted to challenge the information that was held on file. He might have made a request for rectification there. So something worth bearing in mind, something to be prepared for, and to make sure that your staff are aware of them. Again, requests can be made verbally or in writing. If you want to maintain that information, then it needs to be justified in writing to the individual. So the next bubble refers to restriction, objection, and erasure. Now these are separate rights, but in broad terms, we're talking about limiting or even preventing personal data from being processed. Restrictions are temporary limitations on processing data. Objection refers to preventing data from being processed for particular purposes or perhaps altogether. And an objection is a similar right. It's preventing data from, sorry, I'm repeating myself. Erasure is better known as the right to be forgotten. It's a relatively well-known right thanks to the high-profile litigation involving Google. It will apply in certain circumstances, for instance, where it's no longer necessary for your organization to hold personal data about that person. So perhaps someone who's no longer a tenant but was, you would then need to justify why it's necessary even after the tenancy agreement has ended. And in many cases, it's fairly easy to justify that, at least for a defined period of, say, 6 years. after the tenancy is ended, you would have to justify why it's necessary to hold that data. Finally, on tenants' rights, think about breach notification. Now, it's a common misconception that any personal data breach automatically needs to be notified to the Information Commissioner and to the individual data subjects. Actually, breach notification requirements only kick in where we're talking about relatively high risk personal data breaches, and kind of medium level, moderate level personal data breaches should be notified to the ICO, but only high risk data breaches need to be directly notified to individuals. Obviously, each case will turn on its own facts, but it's important to recognize that actually something relatively serious is required before notification is given. So that's all I'm going to say on tenants' rights. Finally, moving on to data sharing. Thank you, covered it. So when I talk about data sharing, I'm thinking primarily about sharing personal data outside of your organization with third parties. But actually, a lot of this material and a lot of the principles covering data sharing apply just as equally internally, particularly with large organizations like local authorities, where you've actually got totally separate statutory functions being carried out, say between housing and children's services. And often I've encountered bottlenecks or problems or delays in information being passed internally from one department to another. So it's important to have protocols set up to deal with that, to make sure that information flows quickly when it's needed, but with appropriate safeguards. So in very general terms, data sharing might be routine, or it might be occasional. Routine, I think, probably speaks for itself. Occasional personal data is usually where a relatively unique situation has arisen, a one-off emergency situation where information needs to be disclosed. Important thing to say about data protection, and the Information Commissioner is keen to stress this, data protection is not a reason not to share. All it does is it governs and limits, or not limits, but imposes safeguards on how data is shared. One of the most important safeguards, if we can flick over to the last slide, is a data sharing agreement or a data sharing protocol. Now, the purpose of one of these documents is to establish rules and procedures in advance that set out the basis on which personal data will be shared, and will ensure that both parties to the data sharing agreement are complying with their data protection obligations. So you need to identify who to enter into data sharing agreements with, who are your partners that you're routinely sharing data with, or who conceivably might be required to make a one-off sharing with. When do we share information and what do we share? So there'll be certain triggers for sharing information, and you'll want to make sure that only the minimum amount of information necessary is shared. Cooperation, if you're sharing information with another external organization, you're potentially both controllers of that data, you're both subject to obligations in relation to that data under data protection. So if a subject access request comes in, then you'll need potentially to cooperate between yourselves as to how that's going to be responded to. That's one example of cooperation, but obviously there'll be other aspects too. And crucially, information security. You might have tip-top information security arrangements in place, but your partner may not. So it's important to make sure that any data that's going out of your organization, you have assurance that it will be treated appropriately and securely. So I think that brings me to the end of my section of the talk. I will, I think, hand directly over to John, who I can see has appeared on the screen. Thanks very much.
Thank you, Matt. So I'm going to continue with talking about CCTV now. In terms of CCTV, it's obviously pervasive in our everyday lives at this stage. For those of us living in London, there's an estimated over 500,000 cameras across the city. And believe it or not, the average Londoner, at least in the pre-COVID times, was being captured on camera about 300 times a day. So CCTV is really everywhere in our lives. And of course, it's used as a tool by landlords carrying out their housing management functions. Now, the first question you might ask yourselves is CCTV collection actually something that involves personal data? And we know that it does, because Article 4 of the GDPR defines personal data very broadly as being any information from which a natural person is identified or identifiable. So CCTV will always, at least in the vast majority of cases, amount to personal data. So in terms of the overview of my talk, what I'm going to talk about are three things in particular. The first are the principles that we need to consider at all times in respect of any data collection, in particular CCTV. The second are the guidance tools that are useful for you as data controllers when you're thinking about policies and procedures around CCTV. And the third issue is data protection impact assessments, which is something you'll need to bear in mind whenever you're rolling out any CCTV on any housing estates or anything like that. So if we start with the principles, if we go to the next slide, thanks, Kuljit. In terms of principles, what we're always thinking about, no matter what we're doing with GDPR, anytime we're data processing, is we have to comply with the principles in Article 5 GDPR. And the four on the screen, there are 6 in total, but the 4 on the screen on your slide are the ones that I think are most relevant in respect of CCTV. The first is the idea of lawful, fair, and transparent processing. So what this essentially means is you always have to have a lawful basis for any CCTV use that you're carrying out. And obviously the lawful bases are all outlined in Article 6 GDPR. And generally speaking, you'll be thinking about either a legal obligation in some cases, but usually the 5th lawful basis, which is an official public task of some sort that justifies the use of the CCTV. Similarly, in thinking about whether it's fair or not, what you're asking yourselves is this complying with the reasonable expectations of a data subject? So is this fair in how we're carrying out the CCTV processing? And then in terms of transparency, what you're really thinking about here is a privacy notice. So that should mean that wherever you have CCTV cameras up and about, you should always have some sort of very clear notice saying something along the lines of images are being monitored and recorded for the purposes of something like crime prevention and public safety. And then it should say who the scheme is being controlled by. So that would be the relevant landlord. And then it should say something like, for more information, call a number, or there should be an email address that people can go to where they can find out further details about, for example, how they would make a subject access request in respect of CCTV information being recorded. The other principle that I want to draw to your attention is the purpose limitation principle. And this is really important in respect of CCTV, because you need to at all times be justifying your use of CCTV, particularly because it's quite an invasive tool, by reference to a purpose. And so the purpose would usually, of course, be crime prevention, public safety, antisocial behavior issues around estates, even sometimes housing management functions more generally. But you should also bear in mind that the purpose needs to be continuing for the entire time that you're using the CCTV. So in the ICO guidance that I'm going to come to later, one of the examples they mention is if you were to have a CCTV system introduced to deal with persistent antisocial behavior during the evenings, that may no longer be justified if that part of the estate or if that area where your properties are is no longer popular during that time. Okay, so you always should be bearing in mind whether the CCTV continues to serve a legitimate purpose. Then turning to storage, the storage limitation principle is something, again, you have to have in mind at all times. This is not just from a practical principle, or rather a principled point of view, it's actually also from a practical point of view, because storing lots and lots of CCTV images actually costs a lot of money in terms of backing up and data storage. So you don't want to be storing it for a great deal of time. I think the example in the ICO guidance is that footage from a surveillance system shouldn't be kept for 5 weeks simply because the manufacturer's settings are set at that retention period. You should be thinking about what you need the CCTV for and how long, therefore, you need to keep it for. And finally, integrity and confidentiality. That's the other principle that I just want to draw to your attention, because that's all about data security. Okay, so that's all about making sure the people who are viewing the CCTV are limited to the people who actually need to view the CCTV footage. If you're passing the CCTV to other bodies, such as the police, as Matt mentioned in the context of data sharing, then again, you should be passing that securely. So it should be encrypted, it should be shared through secure means, always bearing in mind all of the usual security that you would with any other type of personal data. So if we go on to the next slide, Kuljit, please. So then thinking about the guidance and how we sort of manage CCTV, there's a number of guidance documents that are particularly useful to bear in mind. The first guidance document is that from the ICO. It's the ICO's Code of Practice. Now, this does come with a health warning because it hasn't been updated since the Data Protection Act 2018 became law. But the ICO has its usual disclaimer on this guidance, which it has on a lot of older codes of practice, which is that they say there may be some subtle differences between the guidance in this document and guidance reflecting the new law, but we still consider the information useful and up to date. So that's something to bear in mind, just as a caveat with this guidance. And what the guidance does is that it's very useful. It reminds us, in fact, I'm going to put it in the chat just to all attendees in due course, just so you have it after this talk. It reminds us that using surveillance systems can be privacy intrusive. And so it sort of asks people to carefully consider whether or not you actually need to use a surveillance system. And again, one of the examples it gives is the idea of cars in a car park on a housing estate that are frequently damaged and broken into at night. And what you might want to consider before sort of jumping straight to CCTV would be something like improved lighting and whether that would reduce the problem more effectively than something like CCTV. So really, really useful guidance. And the second series of guidance is a series of documents from the Home Office and what was formerly the Surveillance Camera Commissioner and is now the Investigatory Powers Commissioner. And there's a Home Office code of guidance, and that has to be, it must be followed if you're a relevant person under the Protection of Freedoms Act. And you'll be a relevant person if you're a local authority, essentially. For all of those of you who are in-house in local authorities, you fall within Section 33 of the Protection of Freedoms Act, and therefore you're a relevant person, and you have to follow the Home Office surveillance code in respect of any CCTV collection. For those of you who don't fall within that relevant person bubble, you're still encouraged to follow the code. And generally speaking, I think it's good practice to follow the code. The code itself enunciates 12 principles. And again, this code came into force long before the GDPR, but it's quite interesting if you go through it, because lots of the principles sort of almost foreshadow the types of principles that we just referred to in the context of the GDPR. Because those 12 principles talk about things like transparency, they talk about the idea of having accountability, who's in charge of the surveillance camera. They talk about the importance of clear rules and procedures in respect of all CCTV, and they talk about the importance of not storing it for longer than is actually necessary. And alongside that code, there's a really useful sort of checklist or a guide to the 12 principles. And that forces data controllers to sort of ask themselves very important and pertinent questions, asking yourselves things like, what's your system for? Do you review its use? Have you carried out a DPIA, which we're going to come to shortly? Do you have signage in place again? And sometimes you might also not just have signage, but you might want to alert people via your social media channels, if that's how you communicate with tenants about the CCTV that's being used. Who's responsible for your system? Do you have clear policies and procedures in place? What's your policy in place to ensure that information contained on your database is accurate and up to date? So all of those things should be borne in mind if you are collecting any CCTV. In terms of other sources, the main useful other source that I've come across, and I'd encourage anybody who's digging down into this, particularly if you're involved in drafting any policies around CCTV, are the annual reports of the Investigatory Powers Commissioner. Now, for some reason, the reports tend to run 2 years behind. So we only actually have the 2018 one, which was published in March of this year. But they often offer very useful insights into the best practice and where local authorities actually have gone wrong as well, and have lots of sort of anecdotal evidence about various aspects of things going right and going wrong. So very useful, and I commend it to you if you're considering any policy drafting. Turning then to DPIAs, Kuljit, if we go on to the next set of slides. The DPIA used to not be mandatory, but it was encouraged, and under the old ICO code, the idea of introducing any sort of CCTV was deemed to be important. But Article 35 of the GDPR now says that a data protection impact assessment must be carried out in certain circumstances. And those circumstances basically apply in the context of a CCTV, because it will involve systematic monitoring of a publicly accessible area on a large scale. So generally speaking, if you're introducing a CCTV scheme, it may well be mandatory, and in any event, it's just very advisable that you carry out a DPIA. Now, hopefully some of you have experience of carrying out DPIAs, but if you don't have experience, there are templates available on the ICO's website. And essentially what it involves is you looking through the various aspects of how a scheme might be impacting on privacy and how you can mitigate the impact on privacy by taking various measures. So it's sort of a tick box exercise. Well, it's not a tick box exercise, because that would suggest you shouldn't sort of turn your mind to it. But there are lots of boxes that you go through, think carefully about, and come to a conclusion where you're mitigating the privacy impact of the CCTV you're using. Just before we turn to the next slide, I just want to add a note of caution on the personal use of CCTV, because we're increasingly, certainly in my own practice, which straddles housing and data protection, I'm increasingly seeing individual tenants of social landlords who want to have their own CCTV system in place. And generally speaking, that kind of system will fall within what's called the householder exemption under GDPR, in the sense of GDPR won't apply to CCTV if you're using it just in the confines of your property. However, if the CCTV is pointing out onto the public highway or into a neighbor's backyard, or in any way outside the property where it may capture other people, that runs the risk of the tenant becoming a data controller and having to register with the ICO as a data controller. So from a practical perspective, what I would encourage any of you who are encountering this problem to do is essentially try and dissuade tenants from getting personal CCTV, because I think it can be a source of antagonism between neighbors. And ideally, you would have something in your tenancy agreements along the lines of things like satellites, which usually people need permission to erect. And you would similarly have some, because obviously you own the buildings usually in the context of social landlords. So you would have something like a clause stating that there needs to be permission sought before anything like a CCTV camera or a satellite or anything else is erected on the side of a building. Finally then, just thinking about other personal data that you may be collecting in the course of your role as landlords. You'll often have noise recordings, and again, noise recordings in the context of ASB investigations will often amount to personal data, because again, it's very probable that someone will be identified or maybe identifiable from a noise recording. So it should be treated in a similar way. And the ICO code of guidance on CCTV is actually useful in that it talks to a certain extent about audio recordings as well. You'll also think in the context of tenancy fraud and ASB issues about the prevention of social housing fraud regulations. These of course are from 2014, but all of those allow you, once you have an authorized person in place and there's a reasonable grounds for suspecting certain things like fraud, to acquire bank statements, utility or phone accounts. But do remember, there has to be some sort of reasonable grounds for suspicion before you can be requesting from third parties to obtain any of that personal data, and obviously use it then in the context of court proceedings. So I'm conscious of the time, and I think that sort of tees Culture up nicely, because she's going to talk now about court proceedings. But obviously, if there's any other questions, feel free to drop them in the Q&A. And as I say, what I'm going to do now, just so you have it, is in the chat function, which I think I can use for all attendees. I'm going to put some of the links to the guidance documents I've just referred to in.
Thank you very much, John. I'm going to just move the slides on. This is the challenge, speaking and doing slides. When John and I first looked at doing a seminar that was about both how one obtains data and then how one deploys it, we had thought we'd do it as a face-to-face seminar in chambers, but then lockdown happened. And then we were looking at the sorts of topics that might appeal to people. One of the things that we talked about was that both of us are finding around pieces in terms of deploying information. Part of the talk is going to concentrate on the application of what is evidence and slide. So in evidence, part of this goes back to some basic principles about ensuring that when you during issuing your claim or application, that you make sure that you address the reasons for issuing your claim. If it's a possession action, ensuring that you address the grounds, reasonableness, the type of order that you're seeking. If it's an injunctive application or a closure order application, for example, to make sure that you address the specific statutory test along with any guidance that applies with regards to the specific application or claim that you're making. And some of the other things to consider when you're putting your evidence together is to ensure that upfront you've addressed issues such as any information requirements or consultation requirements that there might be within the statutory framework. And bearing in mind some of the observations in the Moat Housing and Harris case that I imagine many of us are familiar with, to make sure that we spell out any reasons why we've come to court without notice, or why we say the application is urgent. And finally, just to explain the order that you're asking for. And sometimes that's going to be a simple draft order that accompanies your claim or your application, but other times your position might be assisted by having a map or having some other photographic or video recordings or noise recordings that will assist you in presenting your case when it comes to the matter coming before a court. And finally, as I've put there on the slide, insofar as there are specific requirements for service, to make sure that you address those in your evidence or in due course if it's a case of something having to be served and then a certificate of service or a witness statement of service having to be prepared. One of the things that I wanted to address is what counts as evidence, and only in a webinar I did last week in relation to the use of housing powers in the context of domestic abuse, one of the questions was, we've only got the police printout, we haven't got any other information about what's happened. The witnesses are reluctant to come forward and provide us many witness statements. Can we use what the police have given us? And the simple answer is you can. And if you have things like CAD reports or criments, as long as they've been redacted to deal with any sensitive information, that is evidence. It can form the basis of an exhibit to your professional ASB officer or enforcement officer's witness statement, or indeed you may be able to get to a place where the police themselves provide a witness statement and deal with some of the CAD and criment information that they have access to. There are some other examples I've put on there. Clearly, when you're relying on a conviction, strictly speaking, the requirement is to have a certificate of conviction, and there is a process by which one applies those. And then other types of evidence that I've listed on this slide are all evidence. They all count and they all have a value. subject of course to the usual considerations in relation to evidence, in that the evidence that's going to carry the most weight is evidence that comes from direct witnesses of an event. And insofar as it's anything that's not direct evidence, so it's something that's been reported to somebody else or it's hearsay, that category of evidence is going to carry less weight. And equally, evidence that has been the subject of being tested in court, so where a witness has been prepared to come to court and be cross-examined, the general principles are that evidence is going to carry more weight, having been tested through cross-examination, than the evidence of a witness that hasn't been tested. And so it goes back to trying to ensure that you put your best evidence forward, and in doing so that you ensure that you exhibit the various documents that you're able to exhibit, or the various CDs which carry the recordings or the noise recordings of what's happened. I'm going to deal specifically with the case of Taylor and Solihull. It's a relatively recent case, but before I do, just to say that one of the trends that I think many of us are seeing in the housing team with litigation is not so much an attack on whether or not the claim itself has been properly made out, but it's more an attack on whether or not the local authority or the housing provider has a policy on dealing with vulnerable individuals, or dealing with complaints of antisocial behaviour or general tenancy management, and whether or not that policy has been applied. And very much the focus of cross-examination and trying to undermine the local authority or housing provider's evidence is directed, efforts are directed at trying to show that that policy hasn't been applied. And or that where in a case where there's considerations as to the correct balance for human rights purposes, and I'm thinking specifically of a case where we recently used a community protection notice to deal with some protests that were occurring. And so protests meant that Articles 10 and 11 of the Human Rights Convention were relevant, the right to freedom of expression, the right to freedom of assembly. And much of the cross-examination wasn't about the bad behaviour of the protesters, because frankly there wasn't much they could say about that, but it was more to do with trying to undermine the officer's assessment of that balancing exercise with regards to human rights. And in that particular case, one of the witnesses had to accept that he'd never had any training on these issues, even though he was at the front line of having to deploy the powers that he was entrusted with. And we then use other evidence to recover the position. But if you do have policies in place, it is important that your officers know about them, that they deploy them, and that you keep them regularly updated. So the case I want to tell you about is Taylor and Solihull. It's a closure order application case, and was originally heard by the Magistrates Court. What had happened is that Solihull had applied for a closure order under the ASB Crime and Policing Act of 2014, and they wanted to rely on the fact that the appellant had been arrested for a drugs offence and what he had said in interview. And in addition to that, they wanted to rely on the fact that his premises had been searched and that various drugs paraphernalia and drugs had been discovered. And the argument that he put before the court, that this is the appellant defendant, is that those matters shouldn't have been admitted by the court because they were the subject of an ongoing criminal investigation, and because he's got the right to be presumed to be innocent until proven guilty, and a right not to incriminate himself in terms of having to answer questions in court, that the magistrates were wrong to have included that evidence when deciding whether or not a closure order should to the high procedure, and who of the arrest, the fact that he had been, and the fact that a search of his property had been carried out, no matter that could be relied on, the ongoing criminal investigation. And beyond, even going further, they said, the High Court said that the products of the search, so the fact that various items of drugs paraphernalia and drugs have been found, could also be relied on, because it didn't mean that the appellant was responsible for them being there, and indeed the closure order test didn't require the respondent to an application to civil, but that these were matters of fact as to what had been found and that they could be admitted within the civil application for closure order. So we do sometimes get this in social housing fraud cases and ASB cases, and sometimes just ordinary possession proceedings where we have concurrent civil and criminal proceedings, and it's a useful case which is a recent case which you can rely on to show that that evidence which might otherwise be questioned because it's in the context of criminal investigation can actually be relied on within your civil application before the court. And it's, as I say, relatively recent, February of this year, and worth knowing about. Other things to think about when you're deploying your evidence before the court is to ask yourself, do you need a hearsay notice? And this often comes up in cases where you have either anonymous witnesses who don't want to be identified, and so you've had to refer to resident A, B, and C, or it might be a case of you being told about something that's happened by somebody else but not actually having witnessed it yourself, and it's to consider whether or not a hearsay notice is required, and also to consider whether there needs to be a redaction to the documents to identify sensitive information. I've listed some of them there, and certainly from a local authority's perspective, some of the personal information that you might want to redact relate to things like email addresses of officers, not just witnesses who have reported things to you, and sometimes telephone numbers and things which you don't want to be in the public domain or produce as part of the evidence. And it's just worth checking that there isn't anything within your documents that you're going to be exhibiting or putting before the court or disclosing to the other side that requires a redaction to have taken place to remove that information. A couple of other matters that I wanted to draw your attention to, more generally in relation to evidence. You will probably already know that the statements of truth have been updated, so there is a new wording since April of this year, and I have even recently seen statements with the old form wording, and I thought it was worth just reminding everyone that that's happened. And the other thing, bearing in mind that it seems that we are at risk of another lockdown, is that it is possible for documents to be signed in by electronic means, and for that signature to count for the purposes of any proceedings that you're involved in. And connected to that is in relation to any proceedings which rely or require affidavit evidence, to consider whether or not you ask up front for permission from the court to use witness statement evidence instead of affidavit evidence. And I'm specifically thinking about situations such as injunctive applications, where you might think that the injunction is not necessarily going to be complied with, and where you might find yourself in a committal situation, committal being one of those few examples that are left now where you have to have witness affidavits instead of witness statements. What I've been doing as a routine in those applications is to be asking the court's permission up front as part of the original claim or application to rely on witness statement evidence in the event I was just over to Matt and the other panelists to consider some questions.
Well, hello everyone. I see that people are awake, and there's been quite a bit of Q&A going on whilst people have been speaking. I'm sorry there seem to have been some technical difficulties while Kuljit was speaking. Now, in terms of, so I can see there are 7 open questions, but some of them aren't really questions. So I don't know. Oh, and they've gone down to 5 open. So should we deal with it in this way? I mean, Matt, do you have any particular questions you wanted to answer live, or are you happy to carry on typing?
Well, I meant to answer Natika's question in writing, but I accidentally committed myself to answering it live. So I think I better honour that promise. Now, there's no general, and I'll be interested for John's input on this one too, just to cover my back, but there's no general exemption from complying with the subject access request due to ongoing legal proceedings. So the only relevance of legal proceedings would be information that's protected by privilege. So you couldn't rely on the fact that you were involved in litigation of itself to justify not complying with the subject access request. That's why I say it's a really powerful litigation tool for that reason. Oh, and John has absented himself from the discussion. That's very, very
Well,
convenient.
I mean, just to feed in a little bit there. So I'm trying to put this in a non-cynical way, but certainly once litigation is in the air, it may be important how you share communications. And certainly I've been involved in situations where parties have been concerned to ensure that all communications go via the legal team and therefore are covered by legal advice privilege, which is the easiest one. Of course, then there's litigation privilege as well, which is a slightly more difficult test. But generally speaking, whenever litigation is in the air, you may be well advised to set up a specific email group these days and or communication channel so that legal is always in the loop. And this should be designed so that it's for the purpose of giving and receiving legal advice to therefore attract legal advice privilege, which is the key to not having to produce it. If anyone disagrees with that?
No, I think that makes sense, Matt. Matt Lewin, sorry for absenting myself there. I agree with your answer. On the final question, I think in the Q&A, Anna Akoli has, where a tenant installed a CCTV without the council's permission that covers the communal area, what actions can the council or neighbours take? The answer there really, I think, is that it's probably a breach of all sorts of different aspects of the tenancy agreement for the person in question to install CCTV in a communal area. And so you're thinking about it's probably antisocial behaviour. That maybe that the neighbours can think about things like nuisance. You should also be telling the tenant that if they actually are assuming obligations as a data controller by filming their neighbours in this way, and that they are likely to be in breach of all sorts of aspects of the Data Protection Act as a result of their actions, because I'm sure they don't have a privacy notice up and they probably don't have a policy about storage limitation or anything like that. So I would encourage you, Anna, to take a very robust approach to that sort of behaviour, because frankly, it's not on.
I would agree with that. I've got at least a handful of injunctions against tenants who've done exactly that, and the courts have no difficulty in granting injunctions to get them taken down.
And Matt, are they ASB injunctions or breach of tenancy injunctions?
We've gone down the breach of tenancy route, but said, among other things, this is antisocial behaviour.
Yeah.
Okay, so it looks as if that is now officially a wrap. As usual, the slides and webinar will be on the website for future reference. Oh, here we go. We've got another question. So we'll carry on fielding the Q&As in writing. Any detailed questions that attendees don't feel have been sufficiently answered in the Q&A, please feel free to carry on communicating with the speakers and take it from there. As I said at the outset, we very much welcome feedback, and we're particularly interested not only in the kind of thing that just popped up, thanking the panelists for their talks, but we're specifically interested in, you know, knowing, understanding your needs. What is it that you would like to see included in future webinars like this? So please do take this opportunity to let us know what we can do to help. Thanks.
Thank you.